Welcome, everybody, to our clinics information session today. You're going to hear from 4 individual clinics, professors and students in these 4 clinics. So you'll hear from the Abrams Environmental Law Clinic and the Exoneration Project Clinic, the Federal Criminal Justice Clinic, and the Immigrants' Rights Clinic. And then we'd ask that you hold all of your questions for the end when we'll have a Q&A session. So first, I want to just really briefly talk about how to enroll in the clinics, because this is the most commonly asked question. There's no application process. You can't lobby a professor to get into the clinic. Instead, you just enroll in the clinics the same way you would in all of your classes. So most of the clinic seats open up in the fall, though in some clinics there are seats available also in the new seats open in the winter and spring. Some clinics are on the bid enrollment system, but other clinics are on the open enrollment system. It doesn't matter though, from your perspective, like enrollment happens at the same time, regardless. And then in August, you'll get an email from the registrar, right? Which will say bidding is open for clinics, the registration portal is open for fall quarter, and that's how you'll do your clinic bidding. Then in November, the registrar will open the registration portal again for the winter quarter, and then in February, the registrar will open it for the spring quarter. Also, one final point here, which is that summer students who work in the clinic and want to continue are automatically pre-registered as returning students in the fall quarter. So I'm now going to turn it over to Professor Templeton from the Environmental Law Clinic.
Thank you very much, Professor Siegler, and welcome everybody. Really excited to see some friendly names, mostly, and really excited to talk about the Environmental Law Clinic, which I co-teach with my colleague, Robert Weinstock. Rob, do you want to raise your hand? And our student, Camille Sipple, is also going to talk about her experiences. So, Camille, I'm going to share my screen here, and here we go. Okay. Great. Can folks see that? Perfect. Great. In the Abrams Environmental Law Clinic, we work on environmental and energy litigation and policy development and advocacy. Our goal is to solve the most pressing environmental and energy challenges in Greater Chicago, our region, and the country. And so we have projects at all of those scales, some located very closely to the University of Chicago, others throughout the Great Lakes region, and Michigan, which we'll hear about from Camille, and then others in terms of national rulemakings. So there's lots of opportunity to have impact throughout the country and the world. How do we do this work? Environmental and energy law might seem narrow to people who have not done this, but there's a lot of different opportunities. One of the most specific ways is that companies are allowed to pollute, but there are limits put on their pollution. And so what we do is actually challenge the polluters when they're violating those limits. We also, kind of at the next level up, try to make sure that there are appropriate limits on the amount of pollution, because they might be complying within the law in terms of how much they're discharging, but that's just kind of too much. And so there needs to be some limits on that. So we'll challenge those permits that are issued by state and federal government. We also try to change the playing field, right? Sometimes you're at a disadvantage, and it's important to have the right kinds of rules and laws that can then be enforced through these permits and individual requirements. Under the environmental statutes, we can actually hold government agencies accountable if they're not doing their jobs, particularly in terms of promulgating rules. We saw a lot of this under the past administration, promulgating rules themselves that were illegal, meaning they didn't comply with the Clean Air Act or the Clean Water Act. And we also do this in the context of developing innovative approaches for improving the environment. At the University of Chicago, we think about market-based solutions, but anything which improves administration or administrability, or just makes it easier for companies to comply, or easier for citizens or the government to enforce the law. I'm not going to go through every organization that we work with. Here's some logos of most of them. I think I would just summarize them from being true grassroots organizations formed by citizens who are concerned about pollution in their community, to regional organizations such as the Environmental Law and Policy Center that works in the Midwest, or Western Environmental Law Center to truly nationwide organizations that often have international impact as well. And we often work with these clients, multiple clients on multiple projects, so we get the kind of consistency of working with them. Our work focuses on 4 areas primarily: clean energy, Clean Water Act enforcement, lead contamination, and Threatened and Endangered Species Act protection. I'm going to skip the first point under clean energy because Camille's going to talk about that in detail. We are involved in federal litigation, both decisions by the administration that allows for companies to mine coal on federal lands. So in a sense, our lands are responsible for about 50% of the coal that's burned in this country. And so we've been involved in challenging those permits and also working to ensure that there's good federal regulation related to kind of the combustion side of it, right? The power plants and motor vehicles, right? Because transportation is now the biggest contributor to greenhouse gases in the country. Under the Clean Water Act, if the government is not enforcing the law, we can bring cases, such as we have a case against US Steel, which has contributed too much hexavalent chromium to Lake Michigan. Trump Tower downtown is violating in terms of how it's taking water out of the Chicago River. And we've got other efforts to try to improve water quality on behalf of residents on the south side of Chicago. We work with people of color in a low-income community in East Chicago, Indiana, trying to address contamination and the Superfund site that they live on. And we try to tackle that issue kind of more broadly in public housing across the country. And then the Fish and Wildlife Service has done a poor job generally of making sure that species get listed. And so we're pushing on that as well. I'm going to turn it now over to Camille, who's going to talk for about 6 minutes, leaving 1 minute at the end for Rob to wrap up. So Camille.
My name is Camille and I'm a 3L in the clinic. I think I've been in the clinic for 5 or 6 quarters now. I'm going to talk about the client that I've been working with the whole time that I've been in the clinic, which is called Solidarity. Solidarity is a really small nonprofit in Michigan, and the company that we're always going up against as Solidarity is called DT Energy. I like to kind of think of this as like a David versus Goliath sort of situation, which is very fun and exciting. So if you go to the next slide, our client Solidarity is located in Highland Park, which is an area completely surrounded by the city of Detroit. And you can kind of see here the image of Highland Park being tiny, tiny little dot right in the middle of Detroit. Highland Park, Michigan is primarily a very diverse community. The majority of Highland Park is African American. And it's also a very low-income community. The median household income is about $17,000, and about 30 to 40% of the population is below the poverty line. I actually skipped a slide, Mark, so if you can go back. So DTE is the company we are going against, and DTE is huge. They're a regulated utility that's publicly traded, and they sort of work with the majority of Michigan, about 2.2 million customers, and then they make about $12.2 billion per year. So when we work with Solidarity in the community, we're often advocating for a lot of different things, but they have a really interesting backstory. Solidarity was actually founded when DTE Electric removed more than 1,000 streetlights from the community. And so since that happened, Solidarity's goals have sort of been advocating for people-powered clean energy, like the installation of solar-powered streetlights and the development of community solar. If you go to the next slide, Solidarity is really involved in the community. They're often working on initiatives that help local residents save money on energy bills, and they are out in the community always advocating for a just and equitable energy system for all. So it's great working with them because they're always really involved in the proceedings. So the proceedings are always in front of the Michigan Public Service Commission. And that's a board that's located in Michigan that sort of oversees any utility proceedings that relate to energy. We have a general focus when we're at these proceedings in front of the Michigan Public Service Commission. We're always advocating for energy democracy, which means putting the power of decision-making in the hands of the people in the community. We're always advocating for low-income access and affordability. Another part of access can be actually locating the solar installations within the communities themselves or the improvements, et cetera. We always advocate for community and stakeholder engagement, so asking the company to actually engage with the community it works in. And then the other two sort of aspects are distribution, safety, and reliability, and public health. Many of these communities are just disproportionately located near pollution sources like coal plants. They experience disproportionate amounts of power outages, and they also experience disproportionate amounts of down wire incidences. So we're always advocating for sort of increased updates to the electrical grid in these communities, and sort of ways to mitigate the sort of harms in these communities. These are just some examples. If you can go back, Mark, if you just look at these are just some examples of arguments that we've made. We've argued for low-income energy offerings, like different pilots, and then sort of like value of solar. So valuing of solar very specifically, including not just the financial aspect, but also the community benefits. And then we've also worked with clients that wanted to put solar panels on low-income housing units, for example. So these are just some of the arguments we make in the proceedings. Most recently, we actually were engaged in settlement in front of the commission, and we asked DTE for something very specific, which was a very wide community solar program. Two aspects of that were community ownership, and the other was an oversight board that would actually involve low-income people in the community. And DTE countered with a pilot with 3 different community solar projects, one of which would be located in Highland Park, I believe, and DTE ownership. DTE would own those community solar projects. It would also involve a community solar council, which was kind of similar to the oversight board we proposed. So while there are differences in the offers that came up in settlement, we believe that these projects do really represent meaningful progress. And this is the first time that this has sort of happened, that DTE has been willing to do this. And DTE is actually putting up I think millions of dollars or $1 million towards the cost for these projects, which we're really happy about. As a student, I have done a ton of things with the clinic. I've recommended strategy of the client, engaged in stakeholder processes, and filed discovery requests, reviewed discovery requests. I've written testimony. I got to conduct cross-exam of high-level executives. I've written briefs and reply briefs and exceptions to decisions. So if you are a student who's interested in the clinic, I would highly, highly recommend it, especially if you're interested in environmental and energy issues. I've gotten a ton of experience out of the clinic and a lot of mentorship. I love working with Mark and Rob. So with that, I will pass it over to Rob.
I just want to very briefly wrap up. I know our time is just about over. I think what Camille hit upon is something true of the broader clinical experience in the Abrams Clinic. You get incredibly experience with incredibly complex litigation on the civil side of things. You can hear a lot about criminal litigation today, but we do complex civil litigation. It's in a regulatory and administrative law context. So if you're interested in admin, if you're interested in other areas that are heavily regulated, it's great experience. And finally, what really excites me about our work is the breadth and diversity of what we do. It's both in terms of where we litigate, on behalf of who we litigate, the fact that we range from legislative work through nuts and bolts litigation, and also the fact that you get to learn a lot about science, learn a lot about economics and industry and the way these things actually work, and actually do some real public policy work at the same time as you have opportunities to litigate and do things like draft testimony and do discovery and all of that. We need more people like Camille, and we have such a good time working with you. And so I just encourage you to reach out to Mark or I. And with that, I guess turn it over to the Exoneration Project.
So I'm Karl Leonard, and I'm one of the instructors in the Exoneration Project, together with Lauren Myerscough-Mueller, who's also on the Zoom, and she's going to get us started.
Hi, everyone. Like Karl said, my name is Lauren Myerscough-Mueller. I'm one of the lecturers in the Exoneration Project Clinic. We represent innocent people who have been wrongly convicted of generally serious crimes. We mostly represent people who have been convicted of murder. We start representing them post-conviction. So once they've already been convicted, once their direct appeal has ended, and they that conviction has been affirmed. At that point, we are looking at new evidence that might show that the person is innocent or that there were some serious constitutional violations at their trial. And we raise those in a post-conviction petition and do this sort of collateral attack on the conviction. And this is done, typically we start in state court. We're a very litigation heavy organization because we are very fortunate that we get to continue our representation of the person regardless of what happens. So what we're trying to do in the post-conviction litigation is to get a judge to order a new trial. So to agree that there was some sort of constitutional violation or there's new evidence that shows that this person is actually innocent. And then if we win and we get a new trial ordered, we are able to do the retrial if that's necessary. Sometimes the state will agree to dismiss charges at that point, but not always. If we lose, we stick with the case. We will never give up on a case. We're with it until we win. And we will do the appeal of that. If we lose that, then we go into federal court and do habeas proceedings there. We have done a lot with clemency petitions with the governor, particularly during the pandemic, trying to get compassionate release for our clients, and have been pretty successful with that. And we'll get into successes later. But one of the other great things about our organization is that while we're based in Chicago, obviously, and we have a ton of Chicago cases because unfortunately, Chicago has no shortage of constitutional violations and wrongful convictions and is known as the false confession capital of the world, which Karl will get into a little bit, I think. We work throughout Illinois. We have cases all the way to the bottom of the state and throughout, and we actually work nationwide. So some of our students are on cases that are in California, some cases we have cases down in Mississippi and Arkansas and Florida, really all over the place, but the majority are in Illinois. And Karl, I think, is going to get into a little more detail on the types of cases we take and what the causes are.
To emphasize one thing that Lauren mentioned, our cases, all of our clients, we believe, are innocent, and all of them have already been convicted, had their appeal concluded. So they have been found guilty beyond a reasonable doubt. An appellate court affirmed that. The Supreme Court either affirmed that or declined to hear it. So the cards are stacked against us. And like Lauren said, it's a ton of litigation because the state has no incentive to give up. And the burden's now on us to prove that our client is innocent. The state no longer has any burden. So all of our cases involve some sort of constitutional violation, and we raise a number of claims along those lines. And in most of our cases, you see one, usually a combination of several causes of the wrongful conviction. The main cause of wrongful conviction nationwide is eyewitness misidentification. Sometimes this is somebody intentionally pointing to the wrong person, but usually it's a mistake. And there's a lot of new science about how bad eyewitnesses are at actually retaining information about what they saw. So we'll work with experts to prove that in individual cases, which is related to junk science. We have a lot of cases where someone was convicted based on science that is just junk. So arson science has changed a ton. DNA has advanced a lot. Shaken baby syndrome, things like that, where there's supposedly science about what happened here, but we later realized that that science was junk. False confessions are very common, and it wasn't until DNA came along that we really believed that anybody would falsely confess to a case. Most of our cases do involve a false confession where someone was either tricked into confessing, or in Chicago, sort of the old-fashioned way, you just beat them until they confess or electrocute them, whatever it takes. A number of our cases involve that, which is a type of police misconduct, obviously, or prosecutor misconduct, Brady violations, where they don't disclose evidence that they have. A number of our cases involve snitches, so someone who makes a living giving information to the police or improves his life in prison by falsely claiming that our client confessed. Ineffective assistance of counsel exists in most of our cases. And last, but definitely not least, race. So disproportionately, well, people of color are disproportionately affected by the criminal justice system anyway, and certainly disproportionately affected by wrongful convictions. So let's talk a little bit about what we get to do and what our students get to do sort of hands-on. And Lauren, I'll pass it over to you.
The main focus of our representation is the client. We're a very holistic representation, and it's sort of organization, and we believe that it's very important that we regularly meet with our clients, talk to our clients. They're the ones who know the most about their case, and they're the ones who have been victimized by their wrongful conviction. So the first thing we do when a student is on the case during non-pandemic times is go meet with the client and start to build that relationship, because the relationship with the client, the rapport with the client, the trust is so critical in these cases. And these are people who often have been proclaiming their innocence from the outset, and no one would listen to them, and they've been ignored. And it's just so important that we do that. And we go into the prisons with students and meet with the clients. During the pandemic, we've been doing more phone calls, but the prisons have started to open up and visits are starting again. So we are very excited to get back into the prisons to see our clients face to face again. Then we will look into the case, and we dive through all of the files, the police reports, any expert testimony, the trial transcripts, all of that. We figure out who do we need to talk to? What are the claims here? Who might know something? And so we go out on the street and we're knocking on doors to try to get witnesses to talk to us who maybe saw something and never spoke to anyone about it, or maybe testified before and they have since recanted, or might be willing to recant now that so many years have passed. And that's one of the things about our cases. They are very old by and large. We have some cases from 1981, people who have been incarcerated wrongfully for 40 years. And it can be very difficult to go out and do these investigations when a lot of people aren't around anymore. And so students are very critical in looking for people. We get on Facebook, we do people searches, and we try to find where people might be now. And once we're out in the field talking to them, we see if they might be willing to do an affidavit, and that might be the new evidence we're presenting. And we may be, like Karl said, talking to experts, arson experts who can talk about how the science has changed, or eyewitness misidentification experts who can explain how eyewitness identification is very faulty and memory does not at all look like a video recorder. So we may talk to them, the students will talk to them, the students will be involved in every single aspect of this, and then we draft the post-conviction petition where we're raising all of these claims, or a habeas petition if we're going into federal court, but where we're raising the claims of actual innocence, of Brady violations, of ineffective assistance of counsel, raising the newly discovered scientific evidence, that sort of thing. And the students are drafting those, and we're reviewing them with the students and learning through that process of how we make these claims and how we present the evidence in a persuasive way. And the same with clemency petitions. A ton of our students were working on clemency petitions this year. Then we start to litigate. So once we file a petition, typically, almost always, the state will file a motion to dismiss and say that we don't have legitimate claims, or these claims have already been decided in the past, or these claims don't matter because there's so much evidence against our clients. So we litigate those. We file our response to that, and we argue that in court, and we want the students to be involved in that and do arguments on their cases in court to the judge, the oral arguments, and then we hopefully will win that, and it will be advanced to a hearing where we will at that point present all of the evidence of the new witnesses, the scientific experts, things like that. And before that, we're doing discovery. So we're trying to get any other information there might be out there, all of the police reports in the case. And that's actually very important, because while we do have police reports, obviously, before we file the post-conviction petition, we don't have discovery power, so we can't issue subpoenas until we have a hearing ordered. And there have been multiple times where when we issue those subpoenas, we find police reports that were not turned over before, and police reports that show that something was covered up, that an eyewitness identified someone else and they doctored that report and changed it and things like that. So that part is very, very crucial. And so we need to go through all that carefully, figure out if there are new witnesses we may need to go talk to, any new claims we might need to raise. But the evidentiary hearing is very fun. It's like a mini trial. It's bench trial. The judge is the one deciding. We're calling witnesses. The students are doing direct exams, cross-examinations, arguments, and hopefully the judge will order a new trial. That's the goal, at which point we do the new trial. And that is a criminal trial. It's a pre-trial posture. And so we do motions to suppress again, or anything like that that's needed. And the students are involved in all of that. They're involved in the retrial. Again, witness cross-examination, witness direct examination, anything like that, any motions we need to write. And if we lose, we do the appeals, and students are involved in that, in the drafting process. And those take a long time. Obviously, all of this takes a long time. As you can imagine, there are a lot of steps, but students are involved every step of the way and are such a critical part of our work, and have been heavily involved in many of the exonerations and successes that we've had that Karl's about to get into. Karl himself actually was a student in our clinic before he became one of the leaders in the clinic, and had a couple exonerations that he was on as a student or had stayed on and turned into exonerations. So there's a lot of opportunity for that.
Yeah, so as a project, we're up to 117 exonerations. 74 of those are related to this one individual, Sergeant Watts, who was assigned to a housing project in Chicago in the 90s, and he would demand bribes, and if you didn't bribe him, he arrested you for drugs, and he sent a lot of people to prison that way. Leaves, I think, 43 exonerations that are not related to Watts. Just to put that in context and to pat ourselves on the back, that is a lot. A lot of projects only have a few exonerations. We've had a lot of success, which I think is related to what Lauren said about how we're so litigation focused. We do some negotiating with the state, but a lot of just litigating in court. So a few pictures of people getting out of prison and winning in court. I don't know who that young guy is. So this is sort of why we do it. These were students after they got a certificate of innocence for one of our clients, and just the happy moments of people getting out of prison. Lauren mentioned I was a student in the project. When I started working on a case for a guy named Tyrone Hood. We ended up getting him out of prison. I'm still working on his case. It's been 13 years. After we got him out, we filed for what's called a certificate of innocence, which clears his name. That's the piece of paper from the court saying you really didn't do it. We lost, appealed, and just last month won the appeal. So we're now waiting for that to get sent back to the trial court, and then he will be officially exonerated. But I have a little video, like 15 seconds long, of the moment he was released from prison, which remains one of my happiest professional or personal moments. It was just a great moment to be there. So this is Tyrone.
I'm just so happy. I used to see boats. Like now, I see people going home. I say, yeah, I'm gonna walk up out of here. I'm gonna walk up out of here. 22 years.
That's Tyrone. Like I said, we've been privileged enough to be involved in that moment or some variation of it 117 times. So it's really nice. Students get to be involved at every phase, like Lauren said. I love the clinic. I hope that you will apply, and feel free to reach out to us if you have any questions. Not apply, sign up. But feel free to reach out if you have any questions. Thanks.
The most pressing issues in the federal criminal justice system are some of the things that the Federal Criminal Justice Clinic works on. We are trying to address two of the most important civil rights issues of our time: over incarceration and racial disparities in the system. We approach this mission through both individual representation and systemic reform. So our goal is to proactively identify the larger crises that our clients are facing, and then do everything we possibly can to change the system. In our individual cases, our clients write complex motions and briefs. They stand up and argue in front of judges in federal district court and the Court of Appeals. We give preference to 3 Ls, but we always have space for 2 Ls as well. I'm currently running a federal bail watching project with a team of students that's aimed at reducing the number of people who are locked up in jail while pending trial. And a few years ago, actually, Professor Zunkel came up with this brilliant idea of doing court watching and gathering data through that method in federal court. And since then, we've been pursuing this multi-pronged campaign to combat the federal bail crisis. So our clinic students created the first ever federal court watching initiative. And we discovered in the course of this that prosecutors and judges were literally violating the law, jailing clients, and creating racial disparities. So after I presented our data to the federal judges and prosecutors in Chicago, they actually began following the law, meaning that our project changed the entrenched culture of detention in Chicago. But we wanted to go further and change things nationwide. So we decided we would rewrite the federal bail law, along with our then summer students, Alex and David. And we submitted this rewrite to the chair of the House Judiciary Committee, and he liked it so much that he asked me if I'd testify before Congress. And then this past December, he actually introduced our rewrite of the Federal Bail Reform Act as the Federal Bail Reform Act of 2020. So we are having a real impact here. This year, our students, a group of students and I also ran this broader federal bail watching project. We have sites in Boston, Baltimore, Miami, and Salt Lake City. We deputized clinic students from other law schools to also watch hearings, and we watched about 1,000 hearings remotely via Zoom. Since we started working on this project, I've presented our data to like thousands of federal public defenders and dozens of federal judges. And I'm really convinced that our interventions are bringing about change at the national level. So this chart shows federal jailing rates climbing steadily from 2006, but from 2018 to 19, those rates finally leveled off. And by late 2020, they had dropped precipitously. And I'm convinced this is not an accident. It's not just a result of the pandemic. It's also a result of our clinic students' work. I'll now turn it over to my student, Kate.
My name is Kate Harris, and I'm a 3L in the clinic. I joined the clinic because I wanted to work on groundbreaking projects in the criminal legal system and learn from 3 amazing change makers who are leaders in their field. And my experience has been that and more. My main assignment was the Federal Bail Watching Project. So the federal system cages people before trial at a higher rate than any state system, yet that wasn't part of the societal conversation since our clinic started our reform work. And I learned so much from building an impact project from the ground up. The other students and I created the protocols and procedures for this cutting edge project. We gathered data through court watching and ran trainings for students at other law schools. And we are now in the process of drafting a report that details the court watching findings. So our goal here is to change the system by convincing federal judges to lock up fewer presumptively innocent people in cages and convincing Congress to pass our bail law that Professor Siegler discussed. This project gave me and other students many hands-on opportunities for meaningful advocacy work. So for instance, in the fall, the Biden administration asked us to give them a list of things that they could change about bail. And Professor Siegler and I wrote up recommendations that were distributed to federal prosecutors across the country. We then turned these recommendations into an op-ed, which was published in the New York Times. Very exciting. The op-ed made its way across Capitol Hill, and a House member just last week quoted us in questioning Merrick Garland about federal bail practices. And last, if you're wondering, like I did when I was a 1L, whether you really have time for clinic and everything else you want to do while you're in law school, I'm here to say that you do. I was on the exec board for law review and did moot court, all while taking 3 credits for clinic each quarter. The clinic goes an extra mile to support your interest and provides an encouraging community every step of the way. And the professors really provide and prioritize meaningful mentorship opportunities that have been unmatched in my law school experience. So I couldn't recommend the clinic more. Thanks.
I'm Erica Zunkel, one of the professors in the FCJC. And as Alison mentioned, one of the goals of our clinic is to do truly cutting edge work that fills pressing needs in the federal criminal system. This year and last, our clinic has been filing federal compassionate release motions for people in prison who are vulnerable to COVID-19. And we've been very successful in getting our clients released. This year, we actually expanded our compassionate release work to represent people who, in addition to having COVID vulnerabilities, are serving excessive sentences that would be lower today because of Congress's recent changes to our federal drug laws. So federal compassionate release law permits judges to release people serving a sentence in federal prison if there are extraordinary and compelling reasons for doing so. So this year, we represent 3 clients who are serving 25-year mandatory minimum sentences for their convictions in connection with the now discredited fake stash house sting that ensnared 94 people in Chicago, the overwhelming majority being Black and brown men. And our compassionate release work this year and in these cases builds on the totally groundbreaking multi-year race discrimination litigation that the FCJC led from 2015 to 2019. And that was litigation that was spearheaded by Professors Siegler and Miller, and that scores of students participated in over the years. So I'm now going to turn it over to one of our 3L students, Alex Aparicio, who will tell you more about our compassionate release work this year.
I'm Alex. I've spent the last year of clinic working on Duane White's compassionate release case. This is my second year in the clinic. During my 2L year, I was on other compassionate release cases and working with the Bond Project. But I'm going to talk a little bit about Duane's case and try to give y'all an idea of what it might look like if you were to join FCJC and you were to work on compassionate release. So for students, compassionate release cases begin with 2 tasks, and the first is background reading. You and your partner need to get up to speed with the compassionate release law and with the history in your client's case. So that looks like reading trial and sentencing transcripts, looking through prison records. And I really enjoyed this stage because I learned more about how federal sentencing and federal prisons operate doing this than in all my other law school classes combined. And then the second thing you need to do is reach out to your clients, friends, and family members for letters of support. Again, not something I learned how to do in academic classes, but both Erica and the clinic social work team really helped edit and revise the questions I had for Duane and his family. But they let me do those interviews myself. And ultimately, I really connected with Duane's mother. And that connection really helped me stay motivated doing the insane legal research and writing that came later. Only once you've done those 2 things is it time to begin writing your motion. And the wonderful thing about FCJC is that the clinic does not use form templates, never ever. So though we read a lot of briefing in other compassionate release cases, Erica constantly pushed our team to reimagine the motion, to center Duane's narrative, and to stay away from dry legal arguments. I would say my legal writing improved exponentially this year, and the final motion was, different than anything I'd written in law school. We are still waiting for a decision in Duane's case, but Erica has been receiving emails from federal defenders around the country who said that they're using our compassionate release motion as a template, which has been amazing. And then also with Duane's case, the clinic was able to move beyond what you might consider typical legal advocacy. We had articles in the Chicago Tribune, op-eds in USA Today, and Duane's case was mentioned in testimony before Congress that the clinic submitted. And those are just, a few of the ways that FCJC has been able to support our clients and help, students interested in this kind of work think about unusual and unorthodox ways to do that work. So, just to close, I want to say I feel so lucky to have been a part of FCJC. I've learned a ton, and it's been really great, I think, for my general well-being to be in a class where I was constantly reminded why I came to law school. And I'm really excited for everyone on this call to have that chance, whether it's in FCJC or in a different clinic.
So I'm Judith Miller. I'm the third of the professors in the Federal Criminal Justice Clinic. And I want to just tell you a little bit about when we represent indigent defendants on trial level federal felonies. We take these cases through sentencing, appeal, and sometimes even trials. Those can be cases like Professor Siegler mentioned, where we're appointed by the court, or also cases where we join with another attorney. Now, in recent years, separate teams of FCJC 3Ls have prepared for federal felony trials, and students really played a critical role in that. Students drafted all the pretrial motions, and we had some unheard of results. One team's Fifth Amendment motions were so persuasive that the government just gave up on introducing our client's statements at trial. And together, we developed a trial strategy. We answered questions like, what would we tell the jury about why our client was not guilty? What evidence could we use to show that? Was that evidence admissible? We analyzed the government's witnesses. Why were they lying or mistaken? And most importantly, how could we persuade a jury of that? We developed examinations for all of the important witnesses. Now, one of our trials has been rescheduled for next year due to the pandemic, and assuming it happens then, which I think it will, that'll be a fantastic opportunity for next year's FCJC students. I've just been blown away by all the incredible work that I've seen our students do, and we'd really love to work with you next year and invite you to join us in changing the federal criminal system.
Hi, I'm Nicole Hallett. I'm the director of the Immigrants' Rights Clinic. I like to say that the immigration system really brings out the best in our country and also the worst in our country. You know, we have this really strong tradition of being a country that welcomes in many immigrants a year. Historically, we've welcomed in historic numbers of asylum seekers and refugees, and yet the way that the system works right now, it's a system that is complicated. It's a system where the bureaucracy sometimes grinds people up and spits them out. And it's a system that is based on a law that's extremely draconian. And so one of the things that we do in the immigration clinic is we help people navigate that system. But we also address many issues that immigrants have here in the United States that are both inside the immigration system, but just in all of the different ways that non-citizens face challenges living in our society. And so that's why it's called the Immigrants' Rights Clinic and not the Immigration Law Clinic, because we don't just represent immigrants in removal proceedings or in applications, but we really represent them in a broad range of matters. And I want to tell you a little bit about the work that we do. There's something for everyone. I think there's you know, if you look at this list of issues, you know, I think almost anybody can find something that they're interested in. And one of the things I really take pride in as the director is that I make sure that students who are coming into the clinic have a chance to choose which projects that they work on. And so if you have a particular interest in one of these areas, I'll work with you to make sure you're working on these issues. So just to give you an idea, you know, we do kind of the bread and butter immigration work that you've probably heard about. So we represent asylum seekers that the government is trying to deport. There are hundreds of thousands of asylum seekers in the country. Most of them don't have attorneys. And for the few of you guys that I see on that are in my immigration law class, you know that it's impossible to navigate that system without counsel. And yet we do not have an assigned counsel system for the immigration system. So many people are going through this system. Their lives are at stake. They risk death if they return. They're in one sense death penalty cases, and yet they don't have attorneys. And so we're doing that. We also represent human trafficking victims. Right now, we have a case where one of our clients was subject to labor trafficking in Georgia. He was brought here. He was held hostage essentially on a farm in Georgia and forced to work for free until he escaped. And so we're helping trafficking victims stay in the United States, bring their families over, and make sure that they stay safe from retaliation from their traffickers. We also handle a wide variety of national security issues. So national security is sort of a different area of law, but it intersects with the immigration system. One of the areas of focus right now for the clinic is that shortly after 9/11, there were many people who were kind of caught up in the investigations after that had nothing to do with 9/11, but they were targeted because of their nationality or because of their community connections. Many of those people were convicted of material support for terrorism charges that were pretty dubious at the time, but juries were fairly willing to convict anybody of a terrorism offense. And now those people are being released from their prison sentences. And many of them are non-citizens, and many of them have nowhere to go because they're stateless, their countries won't accept them, or they fear torture if they're returned. And so we're doing a lot of representing people who just want to finish their criminal sentences and reintegrate into the community and don't want to be detained for the rest of their life. We do all sorts of detention issues, habeas actions in federal court, in state court, just basically arguing that there are too many immigrants that are detained in this country, and in many cases, they're detained in violation of the Constitution. And so we actually had several people that we got released from immigration detention as a result of federal habeas actions. Civil rights. So non-citizens are often victims of civil rights violations. Right now, we have a case against several state troopers for arresting our client basically because of racial profiling and turning him over to immigration, after which he was deported. So we're bringing in 1983 civil rights action on his behalf. Crimmigration. So the criminal justice system is very, very intertwined with the immigration system. The carceral state has a disproportionate effect on non-citizens because after they serve their sentences, they're subject to deportation because of their criminal convictions. And so we try to limit the number of people who get an even greater penalty than our criminal justice system already requires them to get. Government transparency, we try to make the immigration system transparent, particularly about detention conditions. During COVID, we did a bunch of Freedom of Information Act requests to get ICE to be transparent about the conditions they were holding people in. We have a project where we are representing immigration activists who have been targeted by ICE for retaliation because of their free speech. And we also have another project that we're doing looking at how the city of Chicago and their surveillance data that they collect, the surveillance state that we live in, funnels people into the deportation machine, even though Chicago says that they're a welcoming city. And then finally, the clinic really focuses very much on communities in Chicago. We work with several community organizations locally on the South Side to provide support for immigrants that are, in the neighborhood of the University of Chicago to make sure that we're giving back to the community that we're in. In terms of what you can expect to do as a member of the clinic, you can essentially expect to do everything. One of the things about the clinic is that we appear in all sorts of forums. So, this year I've had students argue in federal court, in state court, and in administrative proceedings. We do all sorts of discovery in the clinic based on our civil rights cases and our detention cases. Students conducted depositions, they wrote complaints, briefs, motions. I mean, they clearly, interviewed clients. Everyone gets to do that. We even, usually every year, we have at least one trial and sometimes multiple trials. One of the things about removal proceedings is there is no plea bargain system. Everything goes to trial. So basically every single immigration case results in a trial. Students handle every single part of that: opening, direct cross, closing, all of the various trial issues. And we also do media strategy. I know the Federal Criminal Justice Clinic talked about their kind of media advocacy. We do that too. And we also do reports about various issues on some of these kind of cross area issues that we work on. We develop reports so that we can do some of that public advocacy. So, it's amazing what the students are capable of. Usually coming in, the students are a bit, just a little bit shy and are not sure if they're going to be able to, for instance, conduct an entire trial. But by the end of the year, they're able to do that. And this work really allows you to make a really important difference in people's lives. Families stay together. Families are able to move forward in their lives. People are protected from an essential death sentence. People are released from detention. And just one final story, because I know we're a little bit short on time. We represented a client who'd been detained for 17 years on essentially bogus charges. And we finally got him released. The government of Rwanda agreed to accept him for resettlement. And he's not from Rwanda, he's Palestinian, but he was very excited to go to Rwanda. He's Muslim and there's a Muslim community there. And he just this morning sent me a photo of him and his son celebrating the Muslim holiday there. His son was 2 years old when he was put into detention, and now they are there celebrating together. And while you can't ever get back that 17 years, as the Exoneration Project surely knows, that was us. That was me. That was our students. That caused that to happen and really changed people's lives. So I would encourage you to sign up if you're interested. I always take 2Ls and 3Ls. I actually do half and half. So if you're a 2L or you're a rising 2L, please consider signing up for the Immigrant Rights Clinic.
This slide tells you about the expectations for enrollment. But any questions, guys?
Thanks for the presentations. I guess I just first have a logistical question about clinic enrollment generally. I know that Professor Siegler, you mentioned that some of the clinics are sort of embedded in the bidding process and some aren't. So for those that are involved in the bidding process, is it selectivity based on how much you bid, and then those that aren't, it's more of a random allotment, or are there other factors that contribute?
My understanding is it's just based on, it's bidding like any other class. So if you want something badly enough, you bid it high. I've never bid on things because I'm not a student. So I don't know like what it entails from you guys' perspective, but I think that's the answer. And I think you should check the website to see which clinics, have just open or just have enrollment for 2Ls and 3Ls equally, and which clinics kind of prioritize 3Ls and then take 2Ls in the remaining spots. But I'll say from our clinic's perspective, we've never filled up with 3Ls yet in recent years. We've always had room also for 2Ls, but people have to bid it high.
I wanted to ask to the staff in the environmental law clinic, whether any of their work covers issues around emerging contaminants.
Yes, we have done some things through our Clean Water Act work on emerging contaminants. We've looked at issues of plastics, also at some of these Superfund sites. There are issues associated with PFAS and PFOA as well. So yes, it is something that we have had as part of our work. There are lots of different ways of describing or classifying our work. I just chose one way, and happy to have further conversations about that with you.
I want to ask about the FCJC clinic. I was wondering if there's any prerequisite for this clinic, and also the second question is, when we get into the clinic, will our preference perhaps for a particular project be considered in assigning work?
There are some prerequisites and co-requisites, but they're listed on the website. If you have a real problem with meeting them, you could send the three professors an email and see if there's a way to figure that out. Again, they're all co-requisites as well, so you can take them during the same year as you're taking the clinic. And then, yeah, we do have a system for gauging people's interest. We can't promise project assignments, but we have a system for gauging people's interests that Professor Zunkel has developed that has worked really well in making sure people have the project they want.
I think that that's consistent across the clinics. But definitely feel free to reach out to individual clinics or clinicians about how they do it. But I think we try to work with you, recognizing that in a small school, classes are not always offered when they should be, and we don't want those to preclude you from joining the clinics. And we do want you to be interested in what you're going to be working on.
Question in the chat, which is, can we talk to current students working in clinics? Is there a list somewhere? That's actually a great question. Does anybody know? I don't know if there's I mean, there is an official list, but does anybody know if that list is posted? And if it's not, you can certainly email any clinic professor and say, I'd like to talk to a student in your clinic.
Alison, I was just going to add on that. We work closely with the student groups that have interests in our areas as well. So you may look to students who are in the Environmental Law Society, for example. Many of those 2Ls and 3Ls will have taken the clinic or be in the clinic now. So that would be another route to get the same sort of student-to-student advice or intel. I think that question is looking for.
Great point, Rob. And also, like, students and defenders, the defenders organization are often that comprises people from a whole bunch of clinics. And Alex was, a co-president of defenders. Also, you can definitely reach out to any of the students who are on this call, of course. I actually just got one more question, so I'm going to say it, and so anybody else can answer this question. I'm just going to state it. How should we think about choosing between two clinics if we are undecided?
Do them both. You've got 16 clinical credits you can spend. You can only do 9 with each of us, so you don't have to choose. So I think that's my first answer. The second thing is, I would say if you really do have to choose because you have limited time, and I recognize that, think about what skills you want to develop and what substance you're passionate about and see if there's a blend there. If you're really committed to being a trial lawyer, that might push you one direction or another. If you think you're going to go do IP law and you want to learn about heavily technical and regulated places, industries and areas of law, that might push you somewhere else, right? And so you can think about the skills dimension as well as the substantive dimension, which might help you parse it. But many students do multiple clinics, and I think they get different things from both of them and all three of them, and I recommend it.
I mean, we clearly want you to be interested in the subject matter of the clinic, right? We want students who are really passionate about the work, but even if you don't think you're going to go into that field after you graduate, that's okay, because many of the skills, most or all of the skills that we learn in clinic are transferable to a number of different, kinds of law. And so, if you're interested in IP law, but you want to take, the environmental clinic, there are so many skills that you're going to learn that are going to be transferable. In my clinic, we do federal litigation. Federal litigation is very similar no matter what kind of law you're doing. So, trial skills are going to transfer over. So don't worry too much about doing something that's going to get you experience in the particular subject matter that you're going to work doing at your firm or whatever. I would focus on what are you interested in and what skills you're going to learn.
More question here actually, which is what are the opportunities after the 9 credits, i.e. student directors? So actually turns out that you're totally limited. We have no control over that. You're completely limited to only 9 credits per clinic. Some students do those 9 credits though over the course of 2 years. So they stay in one clinic for 2 years. They do 3 credits during 1 year, let's say, and 6 credits the next, or vice versa. They break it up in that way. So those are opportunities and options, and you can always email a specific clinical professor if you have questions about how to sort of divvy up your clinic credits. But as Rob said, there's also the opportunity to do multiple clinics and take even more credits than those 9 in the one clinic. Oh, and then there's also the point, thank you, Camille, of logging clinic hours as pro bono if you go beyond. So that's something that some of our 3Ls do if they've maxed out their clinic credits. And of course, one more answer to the question that Rob answered is simply talk to students, talk to clinic professors, get a better sense of what each clinic entails.
Don't be scared to pick. I mean, if you might have to pick at some point, although I would encourage you to figure out ways to not pick if you don't have to. But whatever clinic you do take will be a great experience. And it can feel really paralyzing. I'm someone who's sometimes paralyzed by choice, and it can feel really paralyzing when you're faced with 2 excellent options and it feels like so much is on the line, but it's really not. Whichever one you pick will be a good option. And as Professor Hallett said, will offer you skills that will help your future career, regardless of the subject.
I don't see any more questions in the chat, so I hope everyone will please join me in thanking all of the professors here for and the students for phenomenal presentations today. If we could have a round of applause. And thank you to all of you students who attended and are interested in our clinics.
We are so excited to work with you and other people. Like, we love it. It's like a big part. I feel like we're here as opposed to being either federal defenders directly or in NGOs, because we love the teaching aspect of this. But we are in the clinics because we love the practice piece of it, as opposed to our research colleagues. And so we are so excited about the opportunity to work with you in these areas to help you improve and be excellent, compassionate, successful lawyers.